It's an honor and privilege to be invited to interact with you in the hamlets of tribal people by the police and police in Vizag Forest. It's also a pleasure to be part of this Indian Association of People's Lawyers as I have been actively involved with the Andhra Pradesh Civil Liberties Committee from 1980 to 90 and also practiced. He gave a very interesting, excellent judgment where he said, why don't you give habeas corpus remedy in the judicial first-class magistrate court? So I argued, and naturally the first-class judicial magistrate said, if you wanted to argue a constitution article 21, you have to go to the High Court. So it's an occasion to remember all these, and I'm happy. When Arun asked me to speak about social movements and judiciary, I was really puzzled. What should I speak? But then I started thinking and then trying to articulate three important issues which I thought which are very relevant in the contemporary times. The first issue I would like to look at is of course, we have to first acknowledge the post-emergency Indian Supreme Court and how it has reinvented and created new weapons and tools for the protection of rights of the oppressed and bewildered, or in the Justice Krishna Iyer's word, Daridra Narayanas and poorest of the poor. Then after that, then there's a very interesting book I would advise all of you to read, very latest book by Anuj Bhuvania. Happy to see some of our students coming back to teaching. So Anuj was my student in the NLS Bangalore. His recent book we should read with very caution. He is Courting the People, Public Interest Litigation in Post-Emergency India. This was his PhD thesis in Columbia University, and very few lawyers and law teachers go back to the social science. He is currently teaching anthropology in South Asia University. Very interesting, but we should read with, I thought I'll take the first issue of how do we understand and analyze the public interest litigation in the post-emergency Indian Supreme Court in 80s and 90s. That's the first theme I wanted to discuss with you. Second theme is, that's my area of interest more than 2 to 3 decades after working with the Andhra Pradesh Civil Liberties Committee as anti-torture jurisprudence, and interestingly way back, very few in 1980s courage to question the judicial activism. Very few, maybe only Professor Muhammad Gauss at that time, the professor in the constitutional law in Srikrishna Deva Rao University. 1995, I remember in the Andhra Pradesh Civil Liberties Committee State Convention, he said judicial escapism in case of encounter deaths. So I'll try to briefly look at. And last theme I would like to look at is Supreme Court and free speech. So I venture to touch upon some of these. I know it's very difficult in 20 minutes time, but first is public interest litigation. Where are we leading? We have heard some of the speakers in the pre-lunch session, and how do we understand, is still the liberal potential of the Indian Supreme Court or High Court is available? Article 32 is hijacked by the corporate interest or personal interest, we should look at. And second is anti-torture jurisprudence, and the third is this free speech. I started with this, that post-emergency Indian Supreme Court redefined itself as a protector and guarantor of rights of people, portraying itself as last resort for the oppressed and bewildered. One of the legal scholar, Balakrishna Rajgopal, his article on Supreme Court anti-poor jurisprudence, he says that of course, it's not an exaggeration. We have seen the women's movement, labor movement, human rights movement, and environmental movement have used in the post-emergency, particularly from 1980 Indian Supreme Court. But he says there is an anti-poor bias. And as we all know, as law students and lawyer, Professor Upendra Bakse's path-breaking article on taking suffering seriously, where he said for the first time, Indian Supreme Court has become Supreme Court for Indians. And Baxi himself later on said in 90s and 2000 it is a structural adjustment of the social action litigation. When Professor Baxi said the Indian PIL has not public interest litigation of the United States but the social action litigation, as we have seen this era of the public interest litigation, there is a partnership between the court, the public spirited people, social movements and the investigative journalism. And that we have seen, this was a remarkable period. Post-emergency Indian Supreme Court, particularly in 1980s, this was a remarkable phase for all social movements, which has created new hopes and aspirations for Daridra Narayanas, and the epistolary jurisdiction encouraged people to approach courts, and court acted as an ally of social movements. In 1980s, court also evolved public interest litigation jurisdiction by diluting the requirement of locus standi, and we have seen they were just students of the post-emergency, active in the student movement and civil liberties movement. We used to write postcards, telegrams. If somebody is arrested, immediately send a telegram, go to the police station, and these are the several things, and we have used postcards and writing letters to the Chief Justice and the Supreme Court and High Court. We have used that, and that was a really remarkable era where any person can bring a litigation in the public interest. As we have seen the decisions of the Supreme Court in Hussain Era cartoon, Bandhuva Mukti Morcha, Sheila Barse and other cases prove this. Let me now come to what Anuj Bhuvania's argument in this book. Anuj Bhuvania says, at the time of the birth of public interest litigation, the court needed a public-spirited petitioner to stand in for public at large. But over a period of time, even this became unnecessary, and the court could fold the public into itself, court appropriating the public, and they don't require a public. We demonstrate further in 2-3 important cases. And in the initial years in each public interest litigation case, behind the public-spirited petitioner, the court could see the faces of particular people in urgent need of justice. In 80s and later, the matters of general policy in which petitioner stands for the entire people rather than the individual victims of injustice. If you remember, I think very recently Justice Thakur, the former Chief Justice of India, in one of the cases, he questioned even Prashant Bhushan when he is arguing, bringing before the PIL. He dismissed the PIL. Okay, so he demonstrates that you look at Sheila Barse case in 1988. Sheila Barse has brought several interesting cases before the Supreme Court, but Sheila Barse in 1988, she is challenging the rights of the children in the prisoners. So Sheila Barse in 1988, she filed this petition about rights of children in prison that marked the beginning of the process where she wanted to withdraw the petition. See the Supreme Court, when she was so frustrated, when the court is not moving and there were repeated adjournment and adjournment, he said, Supreme Court, I wanted to withdraw. And the court noted that only private parties can withdraw the claim and replaces the petitioner Sheila Barse with Supreme Court Legal Aid Committee. Anuj is right. This marked the court beginning. This marked the court beginning of claiming the ownership of public interest litigation and deciding its direction. And from mid-1990, he says, this process went one step further. Court now began to willfully displace the petitioner and appoint a senior advocate as amicus curiae. He says in Vineet Narayan case, Justice J.S. Verma, we know the important in 1997, the political corruption in Jain Hawala Dairy case. Anuj rightly observes that once the petitioner made dispensable, the remit of public interest litigation could be enlarged and extended in an unanticipated direction as per the whims of the court. The court appropriation of public in public interest litigation and reclaiming this place for itself, Anuj calls in his words as a courting the people. With the result we have, he says, a new kind of judicial process that has emerged, entirely court-led, managed, same time even initiated and implemented by its own machinery. And Anuj argues that PIL was a tragedy to begin with and has over time has become a dangerous farce. It ultimately resulted in decline of the role of public interest petitioner. But I don't want to dismiss Of course, there is a positive aspect in Anuj, but also let us not be pessimistic and we should use that. Let us read, that's what I wanted all of you, read the Anuj book with care and caution, and I agree that there is a shrinking space, but there is a space is available, and this space we should use, let us not ignore. Still, this is a relevant space for the poorest of the poor to challenge the injustice. And Aditya Nigam points out that again looking at the PIL in 80s and judicial 80s and judicial 90s. Aditya Nigam in another article says the first phase of PIL decisions in 1980s he is very remarkable, as we have said. Second phase of PIL he calls as a brass band of neoliberalism. He mentions about, some of us we are aware, about Almitra Patel decision, Umadevi decision, Naglaman's decision under this phase. And Supreme Court also has accepted hands-off approach in economic policy matter, and it is evident in Narma being conscience keeper of the capitalist class. This is a decade when Olga Telly's judgment was overturned by Almitra Patel case, where the Supreme Court stated allowing the people who build their homes over generations of public property to remain on their land, they equated them like a pickpockets, those who are occupying the public place. Where is Olga Telly's judgment, which has interpreted right to live with dignity, and it said pavement dwellers also have a right, and directed the Bombay Municipal Corporation at the time provide an alternate phase. And where is this Almitra Patel case? So when the Supreme Court overturned in another case, in the decision of regularization of contractual employees, Supreme Court also marked that their predecessors had labored under the misapprehension that India was a socialist republic. This is the Indian Supreme Court is speaking in the context of regularization of the contractual employees, saying that preamble, the word socialist has no relevance in this context. So the next theme I would like to briefly explain about anti-torture jurisprudence. And what we have seen is the Supreme Court's jurisprudence in the rights of individuals in detention, such as custodial torture, deaths, rights of prisoners, and sexual violence in custody. I think very interesting, positive, progressive jurisprudence in this area is reliance on dignity of the person. But Supreme Court failed to develop a clear framework of dignity. This is another Anup Surendranath. If you have not read Death Penalty Research of the National Law University, Delhi, all of you must read. This is the first time in empirical research into all the cases of death penalty in India. Anup mentions that even though the Supreme Court in creating an anti-torture jurisprudence, they have said they use the dignity, but the framework of the dignity, principles of the dignity are still to be developed. Anup also mentions a very interesting argument, which he says, Nandini Sharpati, I know all of you as a criminal lawyers and human rights lawyers, we know Nandini Sharpati case in 1980, where Justice Krishna has brought the American jurisprudence of into the Indian context, Indian soil. So Nandini Sharpati case, along with Sheila Barse of 1983, the first time right to the lawyer, rights of the arrested person, the list of the arrested person should be sent to the legal aid committee of the respective place, and also articulating for the first time right to free legal aid after the arrest. Sheila Barse 1983 is a remarkable judgment in that context. What is missing in this is neither Nandini Sharpati nor Sheila Barse nor even D.K. Basu later on in 1987 have provided even now right to legal aid in the police station. Even though in the D.K. Basu peripherally they mention about, not even in the Legal Service Authority Act 1987. So if you read Nandini Sharpati progressive jurisprudence with Sheila Barse, D.K. Basu, what should have been done, what is the gap in this anti-torture jurisprudence is still this right to free legal aid in the police station. When we were working with the Andhra Pradesh Civil Liberties Committee in Warangal and several other places, what we need to do whenever we came to know about any person who is being arrested, immediately we used to rush to the police station. That was a simple, effective method to prevent torture. Another issue is in the case of judicial escapism, which was shown in the case of encounter deaths. 1985, Chaitanya Kalbag versus State of Uttar Pradesh. 3 writ petitions came before the Supreme Court. One is killing of the dacoits in Uttar Pradesh, and another one is Tamil Nadu. Rajni Kothari was the chairman of the People's University at that time, and another one is the encounter deaths in the state of Andhra Pradesh. 3 writ petitions they have combined, and the Supreme Court just threw it in 1985, saying that that was the height of the judicial activism, where right to life and personal liberty was more sacrosanct to the Indian Supreme Court, and we have seen the Supreme Court has not given any importance to the providing justice, redress to the victims of encounter deaths in 1985. Of course, Andhra Pradesh High Court full bench has given very interesting judgment which is pending before the Supreme Court. We have to wait and see. As in this case of the encounter deaths, we have already seen how the judicial escapism of the Indian Supreme Court. In the anti-torture jurisprudence, another major gap which is the advocate has mentioned about just now, about speaking about the terrorist cases, where we have this provision in the Criminal Procedure Code, section 197, which provides impunity, where if you have to prosecute any person, any police officer, army, paramilitary forces, those who are involved in perpetuating torture, you need to take the permission, prior sanction of the state government is very important. That is, in the lifetime it's very difficult to get. So let me come to the last issue which I wanted to share with you is free speech. I think all of you might have heard about Lawrence Liang, Alternative Law Forum Bangalore, again one of our students, and who is a proponent of free speech. What Lawrence Liang, he mentions that Shreya Singhal case is the first judgment in decades in which Supreme Court has struck down a legal provision for violating freedom of speech. This is the first time after many years Supreme Court has struck down in the Shreya Singhal case the legal provisions for violating freedom of speech. The court explicitly acknowledged that the internet has radically democratized communication, and this space for participation must be safeguarded from arbitrary laws. What Lawrence says, the real legacy of Shreya Singhal will however lie in whether it can reshape free speech law in areas such as sedition, hate speech and defamation. The judgment reminds us that the role of judiciary in upholding democracy lies as much in redefining the agonistic threshold in preserving the status quo. In the last 2 years, the court has upheld the validity of criminal defamation laws and thereby placing right to reputation over right to free speech. The court has invented a new ground for restricting freedom of speech by taking a public interest litigation in regulating jokes on Sikh community and by imposing ban on pornography beyond governments. From the first information reports filed against Kundanakulam protesters to Kanaya Kumar or Amnesty International, we have seen section 124A, how it was used to suppress dissent. So when the court comes to this conclusion that the complaints was baseless, there is no compensation or any other remedy was provided for the victims of abuse of sedition law unless they decide to file a case for compensation. Let me end with the William Quigley and Nelson Mandela. William Quigley teaches, professor in the Boston University in the United States, who has been writing very effectively on the social change and social justice lawyers. What William Quigley and Nelson Mandela agrees that, I quote, systemic social change comes not from the courts or heroic lawyers or law reforms or impact litigation, but from social movements. Social change lawyers have to work with, assist and are in constant relationship with social movement and to bring about social change. We have seen in this context of the judicial aristocracy, rise of judicial sovereignty, whoever questions and challenges the Supreme Court, we have seen the contempt or jurisdiction may be explored. But in this era of injustice in the criminal justice system, injustice in the human rights area, the 4 decades of the post-emergency Indian Supreme Court also provides optimism and hope. That optimism of hope is social movement and association like Indian People's Lawyers should take up these changes and partner with all the civil society and several other like-minded people to bring systemic social change. And I personally believe that systemic social change comes from the social movement. Of course, other institutions like the judiciary can contribute, but the limited shrinking space is the reality in the coming days. Thank you again for giving me this opportunity to interact and share with you some of my views.